Okay, good morning, everybody. And I just want to let you know that there are three parts to this training session. I'm going to go over the new normal buyer side, reviewing the documents that are involved on the buyer side of the transaction. The first, the buyer broker agreement, which will be part one. So we're going to go through the buyer representation and compensation agreement. Part two of this session will be the addendums that are referenced. Some are optional. Most are optional, obviously, because they're not included in the buyer broker agreement. So we'll go over those addendums, how they're used, when they're used. And then part three will be the buyer broker agreement light, which is the PSRA, the property showing and representation agreement, and a quick session on the open house visitor and not agency document. So all this is timely. The forms release dropped, the final forms release dropped this morning. So all of these forms are no longer in draft form. They are all in the actual usable format. And we are off and running. So there's going to be a couple more videos that I'm going to be producing regarding tactics and how do we utilize or how do we work with these documents with actual people. Today is more about the forms and making sure that you understand what the contents of the forms are. And all this is in preparation for August 17th, which is the NAR deadline for the practice changes. And in all actuality, August 13th, which is when CRMLS removes the buyer broker compensation from the MLS. So there's going to be varying degrees of usage of these forms between that time period. We kind of have a strange window, but it is what it is. So all of this is California based. So if you're seeing this from some other state, then chances are it's probably not going to be applicable to you, or some of it will be applicable to you, but the forms obviously are not going to be the same. So that being said, I am making this available not only to our group, but to anyone else. It's going to be published on YouTube. So again, take it with a grain of salt. These are my interpretations, my understanding of the forms. So it is what it is. So first up, we're going to just go directly to the buyer representation and broker compensation agreement. I'm going to run through the paragraphs. You can't really read it on the document. You may want to print a copy or have a copy available to you. It's no longer read version. This was done prior to yesterday when they were still in draft. So nothing magical about paragraph one. It just identifies the parties and to the agreement and the term. The document defaults to non-exclusive. So there's a couple things that you have to do in order to make it exclusive. And we'll talk a little bit about that as we go. Paragraph two is the terms of the representation. And first thing to understand is that representation period on a buyer broker agreement in California is limited to a max of 3 months. It is default to non-exclusive. There's a checkbox if you want to make the representation exclusive. We'll talk a little bit about what the difference is between exclusive and non-exclusive a little bit later. Towards the end of the document, there is a information box, which is in bold print, which is the second element that needs to be executed if it is going to be an exclusive agreement. Paragraph 2B, property type defaults to single family residence. There is other checkboxes for other property types if you choose to do that, but it defaults directly to single family residence. You specify the location, county or city. Any other description is if you're going to use zip codes, etc. The caution is make sure that you're not too overbroad. Don't say the state of California. You need to make sure that these buyer broker agreements are fairly well defined. Otherwise, you're going to run into problems down the road. And quite frankly, you're not really going to be able to service somebody in a much broader area. Limit it to probably counties In our particular case, it might be the mountain communities. You might use zip codes. That might be another option for you. Paragraph 2C is optional for additional buyer preferences if they want to specify additional buyer preferences in that. And then paragraph 2D is where if there is other buyer broker agreements, or if the buyer wants to exclude from representation some property, it is an exclusion field, so you can utilize that to specify that, have the buyer specify that the representation would not be included on such properties. Paragraph 2E has to do with compensation, so probably the most important part that you get into it. Paragraph 2E is the amount of the broker compensation. Disclosure that payments made by others are a credit. So in other words, if the seller pays for it, it'll be a credit against what the buyer owes. And so that there's a disclosure explaining that. Continuation period for protection of the broker involved properties is a field that would be utilized to protect the listing agent, or excuse me, the buyer's agent from expiration of the agreement or cancellation of the agreement. So you would write in a time period as a buyer's broker to protect yourself. And then there are some requirements as far as notifying the buyer of those broker involved properties. There's a form for that. There's an addendum we're going to talk about later. Paragraph 2F talks about cancellation rights. Paragraph 2G, buyer personal financial information. We'll talk about that. And then paragraph 2H is other terms. So as we get into the boilerplate, we will talk about 2F and 2G, cancellation rights, and buyer personal and financial information. Paragraph 3 puts the buyer on notice that the BCA, which we have reviewed at length, which is that document that explains how commissions work. It's provided both to the buyer and to the seller. In this particular instance, as we get into the boilerplate, that's the first thing that is attached, that the BCA is attached to this buyer broker agreement. So it is in the bundle. Paragraph 4, compensation boilerplate. 4A, again, a reminder that real estate commissions are negotiable. You're going to see that in the the BCA. You're going to see it in the buyer broker agreement. You're basically going to see it everywhere. There is a repetitiveness to that to make sure that everyone in the transaction understands that all commissions are negotiable, and there is no quote standard. Paragraph 4B, broker's right to compensation. So non-exclusive, it has to do with broker involvement. So there has to be broker involvement. Exclusive representation, if there's buyer acquisition, doesn't matter if there was broker involvement or not on an exclusive agreement, the broker is entitled commission as long as the property is located within the defined area within the agreement. The compensation to the buyer's broker is also effective if the buyer or related properties acting on the buyer's behalf actually purchase. Paragraph 4, or element number 4, broker involvement is any of the following. So it defines the following: buyer entered into and was shown by a broker. So the buyer broker showed them the property. The buyer was shown the property by the broker virtually. The buyer made an offer with the broker. The broker performed a market analysis or did some other analysis on behalf of the buyer on the property. And last element that would constitute broker involvement would be the property was introduced to the buyer by the broker. And that doesn't mean that it's just given on a list, okay? But some analysis was done, or there was some communication with the listing agent or the seller on behalf of the buyer, that something was actually done. You didn't just email them an email list, and that doesn't constitute that you have broker involvement. So be careful with that last one, because there's going to be people that think that if they just email a list that they're good to go. That's not the way it works. There has to be actual viable involvement for there to trigger the right to compensation. Paragraph 4C is the continuation. and the safety clause, which you've been accustomed to typically in listing agreements, which we talked about, that you would use 90 days, or you would use some period that you're protected on the broker involved properties that you have given a list to the buyer, either prior to the expiration of the agreement or within 5 days of the cancellation. So it's a little bit complicated, but just know that you need to make sure that the broker involved properties are delivered so that the buyer has that. And then prior to expiration of this agreement or the extension, the broker must deliver that notice of the MBIP form, which we're going to talk about. Okay, paragraph 4 continued. 4D, timing of compensation. So when would someone be paid? Okay, so the first option is upon completion of any resulting transaction through escrow. So the buyer would be paid as normally. There's also a provision in the agreement that if the buyer defaults, so if the buyer defaults on a transaction, technically commissions could be owed. The third element is that damages recovered, compensation will be 1/2 of the damages recovered, not to exceed the amount of the agreed upon compensation. So, and that's after deducting any expenses, attorney's fees, or anything it would take. So in that example, it would be if the buyer sues, let's say there's a default on the seller's side, the buyer sues for damages, receives damages because the seller breached the contract. This is saying is that the buyer's broker would be entitled to 1/2 of those damages minus whatever it is the cost were that the seller or the buyer had to incur. 4E is the irrevocable authorization of payment through escrow. So the buyer is acknowledging that, hey, I'm agreeing to this, and instructing escrow to pay the buyer's agent, buyer's broker. 4F, buyer receives a credit for amounts paid by the seller, except in the case the broker represents both buyer and seller. The listing side fee is not part of the credit. So what this basically says is that, and it's reinforcing again, I said it earlier, that the buyer is on the hook to pay the buyer's broker a brokerage or a fee. This paragraph clearly states that if someone else, if it's a seller or some other party, pays the buyer broker what is owed the buyer broker by the buyer, then that amount is credited towards what the buyer owes. And then it goes on to specify, because the buyer might say, well, the broker received X from the seller. Well, if it's on the listing side and it's a double-ended transaction, that doesn't count. Obviously, that doesn't erase what the seller was responsible to pay. The broker already does not offset what the buyer's broker is entitled from the buyer. Still on paragraph 4, compensation. Paragraph 4G, payments from others that are less than the amount the buyer owes the broker. So what happens then if the seller agrees only to a partial? So there needs to be a conversation between the parties about including the amount owed in the contract, requesting the seller to pay. So that's where you would, in the contract, check the box on the purchase agreement and include that SPBB, which is the request from the buyer to the seller to pay what the buyer owes the buyer's broker. And then the second result, if the seller's not offering compensation or the right amount of compensation that is owed, if the seller does not pay as agreed, buyer assigns rights to broker to pursue the payment. So in that particular instance, what that's saying is that if the seller agrees to pay and they don't, then the buyer is giving the buyer's broker authorization to pursue legally the brokerage from the seller. 4H, disclosure of payments to broker. All payments made to broker by anyone must be disclosed to the buyer. So pretty much standard. There can't be any secret payments or anything like that. Paragraph 5, cancellation. So cancellation of the BRBC. Cancellation is allowed by either party under 5A at any time based on the timeline in 2F. So 2F is going to, in the matrix, is going to specify the timelines. You could extend it. You could either have it be immediate, which is the default, or you could extend it out. If it is non-exclusive, if it is exclusive, then the time period is 30 days. So paragraph 5B, broker shall still be entitled compensation on properties with involvement, provided that the list of properties is delivered within 5 days of cancellation. So that's the distinction between the expiration of the agreement and the cancellation of the agreement. The the form documenting the broker involved properties, if it is a expiration of a buyer broker agreement, needs to be delivered before that expiration. If it is a cancellation, then a 5-day window is allowed. Paragraph 5C is just a disclosure to the buyer, and it advises to notify other brokers of the existence of this condition. So putting the other broker on notice that, hey, there is some properties that I may need to pay another broker if there is involvement, or if I end up buying this other property. So, we need to be having those conversations with buyers, as we've discussed, that talks about the fact, have you talked to other brokers? Have you signed anything? This is a reminder for buyers, again, to make sure that they're having those conversations with other brokers. Paragraph 6, standard agency buyer acknowledgement of receiving the AD. Paragraph 6B, also possible dual agency with the seller. It notifies the buyer that the agent will confirm prior to them executing the contract if dual agency exists. So they would, and they're also acknowledging the form PRBS is in place. So those are two items that are fairly standard, but you're going to be dealing with those things more upfront than you would in a normal transaction, or the way it's always been. Paragraph 7, properties excluded from representation. 7A is an advisory regarding the buyer signing multiple buyer representation agreements. So it's telling the buyer, hey, don't do that. You could be obligating yourself. The buyer agrees to inform the broker in writing if they sign any other agreements for properties identified in paragraph 2B. So it's putting the onus on the buyer, helping them understand that they need to notify this broker. This is a much more formalized arrangement. Buyer agrees to disclose to the broker if any other broker showed them the property in person or virtually, or wrote an offer, or otherwise acted on behalf of that buyer. The buyer may owe compensation to that broker. So again, disclosure and reminders of how these documents work. If the buyer has signed an exclusive agreement with another broker that is not expired or has been canceled, compensation may be due that other broker. You need to have those conversations. And then finally, the buyer agrees to disclose in paragraph 2D any property for which they are obligated to pay another broker. So the list that they received, or they, if they viewed or seen any other properties with another broker, that's where you would put that information. Paragraph 7 continued. 7B, conflicts with other brokers. The buyer is indemnifying if they haven't disclosed they are under an exclusive agreement or disclosed in the matrix. They have no other obligations to other brokers. So the buyer is, again, you're just having to have them confirm to you and confirm to the brokerage that that they have not been involved with other brokers. It's going to take a little bit of doing. There's, buyers are going to be confused with this process. So again, it's an opportunity for you to help clarify what the responsibilities are. 7C is limitation on broker representation. If there is an exclusion, the broker's not obligated to help that buyer with that property. They don't understand that. You're not going to get paid. So nor is the buyer obligated to pay the broker compensation on that property. So you're not going to get paid. You're not obligated to help that person. And that's what the buyer broker agreement says. Now, you may want to help them, but you have to be careful with that, because you could be getting yourself in a situation where you could be in conflict with another brokerage. Paragraph 8, broker authorizations and obligations. 8A, the broker agrees to exercise reasonable effort to fulfill this agreement. So this is talking about what the broker's responsibilities are. Okay. Broker will assist the buyer with locating and presenting property to buyer, presenting offers and negotiating, facilitating the escrow process on accepted offers. Paragraph 2, at the direction of the buyer, they will order and facilitate the inspection process chosen by the buyer. They will also request and provide the buyer with a list of professionals to perform any work that they want to have completed. They will assist the buyer with the financing process, interacting on the buyer's behalf with mortgage professionals. Not to be confused with the fact that we're not going to be acting as a mortgage person, but it is one of those responsibilities that we have to help the buyer sort of work through that process. Paragraph 8C, the broker will also do a competent visual inspection on all residential 1 to 4 properties. That is law. That's nothing new, but again, you're reinforcing to the buyer that that is a responsibility under the agreement. The broker shall deliver all disclosures, materials, or information received or personally known to the broker to the property. So you're going to make sure that the buyer receives everything that they need that you receive or that you know. If you have personal knowledge, that is required to be disclosed. And then the broker will act in accord with anti-discrimination laws. Buyer obligation, the buyer agrees to act in good faith. Buyer 9B, financial and personal information within the time specified in 2G1. Buyer will provide personal and financial information to the broker. If the buyer fails to provide the information, the broker may cancel the agreement. So there is a 5-day window. Technically, once they sign this document, they are required to provide financial information to you. That gives you, as the buyer broker, the opportunity to have a better understanding. Am I wasting my time with this person, or am I in a situation where they can act? And so it gives you that opportunity. You're not required to cancel the agreement. You may want to modify it, or you may want to do something different, but that would be a red flag, much like being pre-approved or pre-qualified. When we talk with buyers about, working with a lender, typically we're not going to want to spend a lot of time with that person if they're unwilling to go through that process and really have an understanding of what they can and can't do. There is a form which we're going to go over in part 2, which specifies the financial obligations and how they would complete that and provide that to you. Paragraph 9. So if either box 2G2 is checked, the buyer agrees to include a term in the buyer's offer requesting the seller to compensate the buyer's broker. This agreement is contingent upon the seller or some other party agreeing to pay in full the amount owed to the buyer's broker. If not, the broker may cancel. So meaning you're not going to have to act as a broker when you're not going to be compensated. If there's no way that anyone is going to be able to compensate you and the box is checked that the buyer can't pay your brokerage, that does give you the opportunity to bail out of the transaction. 9C, reasonable care and other professional assistance. The buyer agrees to read all documents. Have you ever had a buyer say, there's so much boilerplate, I didn't read it? Well, this is a disclosure and a reminder to the buyer that they need to read everything. Buyer agrees to seek desired assistance from appropriate professionals selected by buyer. So if they need tax advice, they need to select and get the desired assistance they need for their tax questions from that party. Or if it's a legal question, which you are not licensed, we are not licensed to offer legal advice or tax advice. We're not qualified to do that. They need to seek out that information from a party, knowledgeable party, professional of their choosing. Buyer is advised to read the attached BIA for items that may warrant investigation. So again, a response to them that there are, quote, customary inspections that are done, but they need to be aware that there are a lot of sort of non-customary inspections, such as in our market, what is becoming more and more prevalent is a sewer lateral inspection, because we've had some issues with that in the past. The local water district recommends that homeowners inspect their sewer laterals. All homeowners do that, but in particular, when there's a deed transfer, that a buyer should be checking that out, because that can be relatively costly and messy situation. Reports and investigations, 9D, buyer agrees to pay for reports, investigations, and meetings arranged by the broker and the buyer. So buyer's agent is going to be coordinating inspections, doing things on the buyer's behalf, which, you know, they should be authorizing, but it also just puts them on notice that, hey, they need to pay for that. Paragraph 9 continued. 9E, buyer material issues. Buyer will notify broker in writing of any items that concern regarding that specific property. So there is a form in the addendum section in part 2 that we're going to go over that's going to talk about that, that can be used for that purpose. So again, it's just a tool for the buyer's agent to have an understanding of where someone is at on their purchase. And are there other things that are critical? So for example, you know, like in our market, access roads, if a buyer does not want to be on an access road, they would state that that would be something that they would put in writing to the buyer's agent, that please don't show me houses on access roads, or please don't show me houses near a school, for example, or some other issue that is important to that buyer. So it's an effort to try and help the buyer give as much information as they can to the buyer's agent, so the buyer's agent can narrow that search and hopefully provide timely and accurate information as to what the buyer is looking for. 9F, incorrect, incomplete, or inaccurate info. The buyer's indemnifying and holding harmless the broker if anything happens as a result of that buyer giving the buyer broker any inaccurate or bad information. Paragraph 10, everybody pays their own attorney's fees except for under the mediation clause below. We'll talk about that. Broker is given 5 days. So this is a supervision element. Whenever a document is signed, it's not binding. It gives the broker the out if for some reason there's something in the buyer broker agreement. This is why it's very important that these buyer broker agreements are submitted to management, because there is a window as far as supervision on that, which is gone if it's not provided. So please make sure that those are submitted. We'll be talking more about that over the next few weeks. But that's all part of the management approval. Paragraph 12, dispute resolution. So fairly common, similar to other agreements in real estate that we're dealing with. But 12A, the parties agree to mediate. So both the buyer and the buyer's broker agree to mediate if there's any challenges or disagreements. If they don't agree and they lose, they could have to pay the prevailing party's attorney's fees. So if they lose the suit, they're not entitled attorney's fees. If they don't participate in mediation, they just go straight to some type of arbitration or other means of recovering their damages. Paragraph 12B, additional mediation terms, exclusions to mediation, just like it is in everything else: foreclosure, evictions, mechanics liens, probate, small claims, and bankruptcy. If there's a lis pens or something like that, other actions that are initiated, then the mediation, there is an exclusion for that. So you're not required to mediate if you're going to do any of those things. Paragraph 13 is legally authorized signer. Signature is deemed to be in a representative capacity for the entity, not the individual, unless it's otherwise noted. The signer is representing the entity is in good standing in California and will provide evidence within 3 days. So proof of capacity, if there's articles of incorporation, if it's a corporation, or trust document, something like that, that it basically says that you will prove that you do have the capacity, you have the ability to sign for this entity. Paragraph 14, entire agreement and acknowledgement. All understandings of the parties are contained in this agreement. The written agreement is required by all parties to change it. So it's putting everybody on notice that, hey, this is our agreement. There is no other, hey, he said this or he said that. It boils down to the writings. That's basically where things are. So obviously be careful in your communications. You don't want to be making promises that are not documented, that could come back and create confusion or hassles after the fact. But this is a catch-all in paragraph 14 that basically says, hey, this is our agreement. Paragraph 15, exclusive representation. So this is the boxed area, which I referenced at the beginning of this conversation, which is also in bold print, which it needs to be completed. And there are three elements of it. That is, again, additional disclosure to the buyer so that they understand that, hey, this is an exclusive agreement and this is what this means. So 15A, advice to the buyer to not enter into another agreement that could be in conflict with this agreement. So, hey, buyer, don't do this. If you're going to look for a property in these zip codes, you are under an exclusive agreement with me. And if you choose to go to someone else, you could create a situation where you're going to be obligated to pay 2 commissions. Paragraph 15B, compensation is due in the time period that is specified area with or without broker involvement, even if another broker is entitled to be paid. So again, very important. This is a contract. Buyer needs to understand it, and that's why they're reiterating this and why there's a second initial for it. Paragraph 15C, 30-day cancellation time period is in effect for exclusive agreements. The language reminds the buyer that there is a protection clause provided broker produces a list within 5 days of cancellation. And as I said before, initials are required for the exclusive agreement to be valid. Paragraph 16, confirmation of compensation. So compensation will have to be verified. So if it's to be paid, if there's a transaction, the buyer's broker is going to have to prove that the buyer authorized them to be paid X. So this gives the broker the opportunity to use one page to provide escrow or whatever other party needs the information to verify that the buyer broker compensation was agreed to. So you basically, if escrow requires proof, which they will, then, or the seller wants to see proof when you submit the SPDB, all that is needed, you don't have to provide the whole buyer broker agreement. All you do is just produce the last page, and that is satisfactory. That verifies that the money is actually owed. Last part of it is the buyer acknowledgement and signatures. So that is the buyer broker agreement. That concludes our portion of part 1 of 3, the buyer representation and compensation agreement. Hopefully that review was helpful to you. You're welcome to post questions on Mastermind or send questions to me via text if you don't have access to our Mastermind group. But that's all we have for now. So shortly I will post part 2, which has to do with all the addendums to the buyer broker agreement. I hope this was helpful to you.